This week on the Communicators, Marc Rotenberg of the Electronic Privacy Information Center. He'll discuss concerns by privacy advocates over initiatives by both Congress and the Obama administration.
This week on the Communicators, our guest is Marc Rotenberg. He is the Executive Director of the Electronic Privacy Information Center. Mr. Rotenberg, if you would start off by giving us a quick primer on what EPIC is.
We're a public interest research group here in Washington. We focus on emerging privacy and civil liberties issues, so issues related to the internet and government surveillance, new business practices. That's what we look at.
And how are you funded?
We're funded primarily by individual contributions, private foundations, occasionally the sale of books, and some legal fees.
Well, Mr. Rotenberg, you have a new administration and a Democratic Congress, new FCC. What's your legislative agenda?
We'd like to see more privacy protection. We think a lot of work that should have happened over the last several years didn't happen, needs to happen. There are real problems in the United States today with security breaches. A lot of information is leaking out of government databases, out of private sector databases. There's a real problem with identity theft. According to the Federal Trade Commission, identity theft has been the #1 concern of American consumers now for the last 8 years. So we see very real issues for Americans, and we hope that the new Congress, the new Federal Trade Commission, and the new administration will begin to take on some of these issues.
Specifically, is there a legislative vehicle that you're looking at to help prevent ID theft or leaking from government data?
There are several good bills in Congress, certainly, but one of the very interesting things about the privacy issue is that it tends to come up in many different areas. For example, the stimulus package that was just signed by the President included important provisions for medical record privacy as part of the effort to build electronic health networks in the United States. And I think there was a very good understanding in this legislation that if we're going to take advantage of new technology to provide medical service and to keep medical information, it's absolutely vital to have privacy safeguards in place. So in fact, this Congress has already passed important privacy legislation. I think we'll need to see some similar activity for the internet and new business practices.
Also here to join in the questioning is Greg Piper, who is with Washington Internet Daily. He's the associate editor.
Good to see you, Mark. Let me ask you about that health stimulus bill, because I know that EPIC and a lot of other groups have said it has good privacy protections, but there's also a lot here that's left to Health and Human Services, to this National Coordinator for Health IT to actually establish standards here. Are you worried that this could go in an unfavorable direction once it's actually out of Congress's mind and it's being taken up at the agency level?
I think it's an excellent question, Greg. I mean, we're happy about the legislation that was passed. As you say, it includes a lot of important privacy safeguards, limitations on marketing, for example, requirements for encryption and other security practices. But there's a lot more that will need to happen to make the legislation take real effect, and part of that will be in the regulatory process. There need to be strong safeguards. We also need to be sure that there's an understanding that the companies that are providing these new electronic health record systems are actually covered under the legislation. And I say this because we heard recently, and somewhat surprisingly, that Google thought perhaps it was not covered because of its business model by the legislation that was just passed. So that point, for Google and for any company that is providing electronic health records in the United States, I think that will need to be addressed as well.
Is this the fault, though, of the way the text was actually drafted, that there is some ambiguity on what a covered entity is?
I think the text is fairly clear on this point. As you know, the original medical privacy regulations, which came about from the 1996 Act, the HIPAA regulations, left the definition of covered entity in such a way that there was very uneven application. Certain types of providers were covered, other types of providers, particularly the big new emerging ones, were not. And one of the key goals clearly in the new legislation is, I think, to make clear that everyone will be covered who's in the business of providing electronic health records.
Marc Rotenberg, what would be your concern with a Google and electronic medical records?
Well, generally speaking, as I said, I think any company that is collecting and making use of our personal medical information needs to be subject to privacy obligations. Now, to be clear, to say that you're subject to privacy obligations isn't to try to tie the company's hands or to prohibit services, but it is to make clear that they take on certain responsibilities when they have this very sensitive information about Americans, security obligations, accuracy obligations, and I think most importantly, understanding that ultimately it's the patient who should control that medical record. If it needs to be made available, for example, to a caregiver or insurer or somebody else, that's part of the responsibility of the electronic health record provider. But if that company decides to go on and to market the information or to use it for advertising purposes, that's a whole nother issue. And with companies like Google and others, I think it'll be very important to be clear about how they can use the information they collect.
Well, what about a company like Cablevision, which is now can tailor commercials to specific demographics? Is that?
This is a privacy issue also. Cablevision, telephone companies, just about any company today that's collecting personal information sees a new revenue stream. They see the opportunity to develop advertising based on what they learn about particular customers. Now, I should be clear, we're not against advertising, particularly when you're talking about something like, viewing a television. Advertising helps support that. But at the same time, I think there needs to be a clear line drawn between the type of demographic targeting, maybe by region or time of day or age, for example, and the collection and use of personally identifiable information, actually knowing, who is watching a show and targeting an ad based on the knowledge of that person. That would be very troubling.
Why?
Well, because I don't think that we want to be sort of profiled and targeted at such a granular level. I think we understand that with advertising, if we pick up, an advertising about outdoor sports, we're going to get, news about products for outdoor sports. Nobody has a problem with that. But if you were watching a television and learned that essentially the television is watching you, we really would enter that Orwellian world. So what privacy laws try to do is to restrict that collection of personal information, draw some boundaries, some lines, so that you can have advertising, but not that detailed profiling.
On this subject, in an internet context, the new chairman of the Federal Trade Commission has warned actually some of these advertisers online that this is their last meaningful chance for self-regulation before the agency may step in and try to set rules or push for some kind of overarching privacy law. Do you think that this new chairman, John Leibowitz, is actually going to carry out this threat, or does his history make him seem that he'll continue kind of extending the self-regulatory olive branch to the companies?
Well, I think will be very important for Commissioner Leibowitz and for the other members of the Federal Trade Commission to move aggressively on this issue. This is one of those areas where I think we've paid an enormous price in following that self-regulatory approach. The consequence, of course, has been that many of these companies have collected a lot of data without any meaningful consent from American consumers. We see, as I said before, increases in identity theft and security breaches. Our view is that this period of self-regulation has really come to an end, and that means that the new chairman will have to establish enforceable privacy safeguards.
Let me ask you about the Truth Commission, which has been proposed by Senate Judiciary Committee Chairman Patrick Leahy. There was a hearing on this past week that would basically investigate some of the more secretive national security programs of the Bush administration. There's been some concern that this may be something of a process that's outside of the constitutional wall, or that it could even infringe on some people's civil liberties to basically have a organization commissioned by Congress to look into this and maybe not be able to adequately defend their names if they don't have to be indicted. What's your view of this? Is this constitutional or just raise civil liberties issues?
I'll admit I'm a little bit troubled by the use of this phrase, Truth Commission. It's not a concept that we have had in the United States, but I think once you get past the name and you begin to think, for example, about the very important role that the Church Committee played in the 1970s in uncovering the abuses that took place and the wiretapping, the unlawful wiretapping and surveillance of Americans in the 60s and 70s, then you begin to understand, I think, what it is that Senator Leahy and the Congress is trying to accomplish. And that is to have a real investigation, a real assessment, to determine what laws were broken and to ensure that this doesn't happen again. As to the constitutional authority, I think this can be done. I don't think it's a problem for Congress. I think there will be some questions in, with respect to particular witnesses about what type of immunity you might grant and what the risks of prosecution are. But those are issues that have come up in the past with congressional investigations. I don't think there would be anything about this particular subject that prevents Congress from pursuing the investigation. In fact, I think it's vitally important for Congress to understand exactly what's happened. As you know, my organization, EPIC, was one of the lead groups pursuing open government litigation after we learned of the warrantless wiretapping program back in December 2005. And it's just this past week that the Attorney General has begun to release some of the memos that provided the legal basis for President Bush to do that wiretapping of American citizens here in the U.S. We think there needs to be a much more extensive investigation, although of course we're pleased by the response. It's a good starting point.
Marc Rotenberg, we've touched a little bit on privacy concerns on a commercial or marketing level and now a national security level. Should companies be allowed to collect information, in your view, on people? And what about the government? What's the limit?
Well, I think a lot of the answers to these questions actually come from a common sense perspective. I mean, companies need to collect personal information oftentimes simply to provide a service to you. If you want a product shipped to your home, it's not unreasonable for a company to ask you for your address so they can ship it to you, and we would never object to something like that. I think it becomes a bit more problematic when the companies begin to collect detailed information about your personal life, about your income, about your gender, about your race, or they go to catalog companies that so-called enhance the profile they have about you, because now they're getting more information about you than you would likely provide to them. And that's where some privacy rules may be appropriate. I think another point to keep in mind is that now we're in a difficult time when the government goes to these companies and says, in effect, even though you may not want to keep this information, we'd like you on behalf of the government to keep this information because it may prove useful at some future point in the context of a criminal investigation. And in those cases, we've actually sided with the companies and we've said to them, look, if you don't need it for your business, then the government should not be able to force you to keep that data.
When you bring this up, it reminds me of a bill that was recently introduced by Congressman Lamar Smith, which would title the Internet Safety Act, which has this provision in there on data retention that would basically create a 2-year minimum period to keep this information. It's been said by some of the critics that this could apply to not just, let's say, internet service providers, but also anyone operating a Wi-Fi access point or even a home router. Do you think this language is broad enough that this could encompass a lot of people that it's not intended to?
You know, I saw the proposal and it may be well intended, but I actually think it's a terrible idea. And it's a terrible idea because it creates a new type of privacy and security risk. In other words, on the one hand, the government says there may be something that will be useful here if we're able to collect that data and force the companies to keep it. But on the other side of the ledger is the fact that now there's a lot of personal information being kept that otherwise wouldn't be available, that's vulnerable to hackers, that's vulnerable to subpoena, that could be used against the individual who wouldn't provide it otherwise. And I think this particular proposal really hasn't been thought through very well. I mean, you can imagine, for example, a world in which the government said, if you're going to use the telephone, we want all of your telephone calls to be recorded, and we want all those recordings turned over to the government because they may help us at some point in the future find evidence of a crime. In some respects, I'm sure the government's claim is probably correct, but the extraordinary risk, I mean, to privacy, to citizens, to businesses of such a world, I think would be obvious. The problem is with this particular proposal in Congress, I don't think people actually see quite how similar that risk is.
Janet Napolitano has proposed increases in domestic surveillance spending and tying databases together, government databases. What's your position?
Well, we have a lot of respect for the incoming secretary, but she has also inherited a number of programs from the past administration that frankly set our forms of domestic surveillance. We are recorded nowadays in many of the cities in the United States by video cameras funded by the Department of Homeland Security. Many people in government and the private sector now carry identity documents required by the Department of Homeland Security. We have border control systems that impact not only immigrants to the U.S., but also U.S. citizens traveling back to their own country through our airports, also operated by the Department of Homeland Security. Our view is that that department really needs to reassess many of these systems, try to determine, are they actually making us safer, and also what are the surveillance risks? This is another one of those areas where the government is collecting a lot of data. It's not clear what's being done with the data, and we'd like to see the incoming secretary shut down some of those systems. Fusion centers, for example. we now have state-based databases that collect a lot of information on local residents, people who work in communities who could be considered possible threats, to the nation's security. And it's, at a certain point, I think almost silly. There's no longer the sense about investigation that there's something that someone's actually done that creates the basis for an investigation. It's more of an effort to gather up the data and see what can be found. I think Homeland Security has allocated almost $300 million for fusion centers next year. That's a lot of money.
So have you seen a change from the Bush administration to the Obama administration?
In some areas, clearly. I think the support for the medical privacy provision was very favorable. I think the President's call for new openness, particularly with respect to government transparency and the Freedom of Information Act, that's very favorable. Changes are taking place at the Department of Justice, which I think are clearly favorable for people who are concerned.
Such as?
Well, I think the rethinking, for example, of the President's authority to conduct surveillance in the United States. The Attorney General's comments earlier this week on that issue, on Guantanamo, on torture, I think have signaled a clear change in direction, which we obviously support, I think most Americans support. At the same time, Homeland Security is not well understood. As I said, it has an enormous surveillance apparatus. It impacts millions of Americans. And our hope, and it is a hope at this point, that the administration will look at that agency more carefully and really assess what can be done to show better regard, I think, for some of our privacy and constitutional rights.
Greg Piper.
Speaking of open government, one of the more novel things about this new administration is its use of technology, especially to make itself more open, but it's also had several stumbles when it does that, and heard from people like yourself and from average users, let's say, in the president using YouTube to distribute his weekly address. And YouTube actually tracking who visited even the page before they turn that function off and just track the visits and views themselves. Do you suspect that there's going to be this kind of similar back and forth game where the Obama administration tries to be more open but ends up perhaps compromising user privacy in its attempts to do that and quickly pulls back? Do you suspect they'll be more responsive?
Well, I mean, let me say, first of all, these have always been the two big issues in government information policy: promoting transparency and openness, which is a very important value in a democratic society, but also respecting the privacy of citizens, which is an equally important value in a democratic society. And what you look for are solutions that aren't simply a zero sum that involve a lot of trade-offs, but actually realize both goals. So we have been arguing for a very long time, first of all, the technology is a wonderful thing to promote access to government information. We have no objection to it, but we think it should be implemented in a way that minimizes or perhaps eliminates the collection of data about individuals who are simply trying to get some information about what their government is doing. And this, of course, was the significance of the debate surrounding the provision of videos on the White House website. Now, it's a great thing for people on the internet to be able to see the president online and to download YouTube videos and other videos, but at the same time, the technique that was used to make that possible involved something called a persistent cookie, which is a tracking tool. It's used by advertisers and others to try to figure out where people are going online and what they're looking at, and also to do some web analytics. We said that's not right. I mean, it's one thing in the commercial realm, we're not wild about it for advertising, but when it's done by the White House for people who simply trying to get information about the activities of the government, it's a real problem.
When you say it's done by the White House,
yes.
Do you think the White House was doing it on purpose?
Well, I think the White House has been experimenting. I think they're trying a number of different tools. The Obama campaign was enormously effective, using Google tools, using Facebook, other online techniques to try to engage people in the campaign, get them involved in government, and I think that's to be supported. But at a certain point, you have to look at some of these techniques a little bit more carefully, particularly once you're in government, and ask the question, for example, do they comply with the Privacy Act? Do they comply with the regulations regarding the use of cookies, which is actually an issue that came up in the Clinton administration when people realized that the websites of the government agencies were setting up could now be tracking folks. You know, you go to the IRS website, you want information about, sending in your return on a delayed basis, let's say, or you have some other problem, you should be able to get that information without the government website tracking who you are or what you're looking for. So this is, as I said, actually been a long-running issue, And our view is that they really need to look a little bit more closely, I think, at the privacy consequences of some of these tools.
Marc Rotenberg, what was Epic's complaint about Facebook?
Oh, well, this is a fascinating story. You know, it's interesting. People say nowadays that young folks and, you know, the Facebook users, Facebook generation, I guess, you know, doesn't care very much about privacy. And our experience has been almost the exact opposite. Over the last several weeks, users of Facebook became very concerned when they saw a change in the terms of service, which appeared to many people to suggest that the information that the users had been putting online, like those photographs and those comments and everything else that people do, were now going to be within Facebook's control instead of the user's control. And the users objected. And we looked into it and we agreed. We thought they had a great point. We put together a complaint for the Federal Trade Commission. We basically argued that it was a violation of consumer law to tell people when they signed up for the service, it's your information, and then to change the terms of service and say, well, now it's our information. I think Facebook thought we had a good complaint too, because when they heard about it, they decided to back off. They went back to the original terms, and now they've got a good discussion going about that service.
Marc Rotenberg began his career here in Washington as a counselor to Senator Patrick Leahy on the Senate Judiciary Committee, graduate of Harvard and Stanford Law School. Greg Piper.
Let me ask you about discussion for the past several years over a general privacy law that may replace some of the sector-specific regulations that apply to health or financial records. Is this something that can be done in a way that will treat all industries equally without perhaps disadvantaging some over others? Or has this pattern of dividing them by their unique regulatory requirements been fairly successful, or at least a model that should continue forward? And do you think that will get attention in this Congress?
Well, let me say I think it would be wonderful if we could enact a comprehensive privacy law in the United States. You know, the Europeans were able to do this several years ago when they were integrating the European economies, and I think it turned out to be quite forward-looking. It was very simple, it wasn't complicated, and it was broadly applied to all industries. And as new business practices came along, new services, they didn't have to say, well, now it's time to create a new law. They looked at the law they already had in place and worked on applying it. It's different in the United States. As you say, we have what's sometimes called a sectoral approach to privacy protection. We've just regulated medical records. We had previously regulated financial records, but we don't regulate, for the most part, internet records. And it creates, I think, a lot of confusion, particularly with the introduction of new services. The problem, of course, we have in Congress is that things get broken up among the various committees. Everybody wants to, you know, to maintain the control over their issues, and trying to get a bill that covers everybody through Congress is oftentimes tricky. But maybe it could be done this year. I think looking ahead, actually, is probably the best approach.
Would this require the creation of any new authorities that actually oversee privacy? We do have a fairly fragmented federal agency system as far as how it's regulated.
Yeah, we do. And I think, you know, not only are we missing a comprehensive privacy law in this country, we're also missing a privacy agency in this country. We have the Federal Trade Commission, the FCC, which both take on a piece of the privacy puzzle, but the reality is that we don't have an agency with a real expertise, competence to regulate in this area and to address emerging issues. And I think this hurts us as well. I do study privacy protection in other parts of the world, in Europe and Asia, and I've been impressed, in fact, by how forward-looking many of their privacy agencies are. I don't think they're particularly regulatory, as some people in the U.S. sometimes charge. I actually think they're trying to imagine a world where you can have, you know, business working, you can have privacy protected, and then you have to figure out what are the public policies that make that possible.
Marc Rotenberg, you talked about emerging issues, but what about emerging technology? Do you keep an eye on that, and what are some of those technologies that concern you?
Right. Well, it's a fascinating area. I mean, the thing about privacy is it's so much shaped by new technology. Look at identity documents, for example. We're about to see many more identity documents that have embedded RFID tags. These are little broadcast tags that basically make it possible to pull information off the identity document at a distance, oftentimes without the person's knowledge. Now, some implementations can be great. I mean, you can use these for price tags, for example, on products in stores, and it makes it possible to go through a checkout line more quickly. Probably saves the store some money on someone actually, you know, going through the barcodes on all the items. But when the identity document is your driver's license and it's sitting in your back pocket and it's broadcasting your identity as you move through a airline checkpoint or even a city street, then I think people would have the right to be concerned. So we look at the introduction of these RFID tags and we say, well, for products it's probably not a problem, or for pets where they're oftentimes used, not a problem, but for people it probably would be a problem.
And how widespread are the RFIDs?
They're being deployed very rapidly now, certainly in manufacturing and the distribution chain. They're used for bulk items. They're used at the consumer level increasingly. As I said, there are several million homes in the United States where pets have RFID chips, make it possible to locate a lost animal. But the big privacy debate, of course, is whether to use these tags for people on driver's licenses.
Greg Piper.
One of the solutions that's often been suggested for protecting privacy is to anonymize records, to basically keep what's useful about information and make sure it can't be traced back to someone. There, to my knowledge, have been a few very prominent instances where anonymization has failed. Let's say a person who is able to be identified from their search records on AOL. Do you suspect that this will become an increasingly viable way to protect privacy and perhaps not kind of undermine the information collection that maybe a lot of business models depend on?
Well, we're big fans of anonymization in the privacy world. I've sometimes said that, anonymity will be to privacy sort of like solar energy, is to the environment. I mean, the idea is that if you can enable transactions, if people can buy things, for example, or visit websites or, communications, transportation without having to reveal their actual identity, you make commerce possible and the privacy risk goes away. But the trick is making sure that the techniques really work. And as you say, there have been many instances where techniques that were supposed to be anonymous actually, were broken. In the new medical privacy bill that's been recently enacted, there are some specific incentives to try to make anonymity work. We hope that approach will be adopted in other places. We actually see this as an area of real innovation. We think the privacy incentives can actually help promote new techniques and new businesses, as I said, that make commerce possible and protect individual privacy.
What should the balance be, though, between, let's say, how difficult it is to track someone down based on their records? There have been many incidents, but is this something where we're setting an unreasonably high bar for people to remain anonymous and really overstating the chance that someone will go to all the trouble of identifying people based on those records?
Well, we have a lot of anonymity in our physical world. I mean, people forget this, of course, but any cash-based transaction is essentially anonymous. When you drive down the highway, for the most part, you're anonymous. I mean, we're still not, routinely reading license plate numbers, for example, and figuring out who's in a car next to us. That may happen at some point in the future, but doesn't happen now. There's a lot of anonymity in city streets. So I think, in fact, we are quite comfortable with anonymity. I think what we're dealing with, particularly with the internet right now, is the loss of anonymity and the consequences not only for privacy, but actually for security as well. I mean, you use the word balance, but to me, when we provide privacy to people, we're also providing security. It's a form of safety. It means that they're less at risk of identity theft, for example.
Marc Rotenberg is the Electronic Privacy Information Center's Executive Director. Greg Piper is Associate Editor of the Washington Internet Daily. Thank you, gentlemen.
Thank you.
Thank you.